Good evening, Chief Justice, judges and retired judges, members of the profession, ladies and gentlemen, and welcome to this third lecture in the Selden Society's 2019 lecture series. May I begin by acknowledging the traditional owners of this land and pay my respects to their elders, those who have spoken for this land in the past and who do so today. That acknowledgement is of particular significance having regard to the topic of tonight's lecture, which is using and proving history in constitutional cases. The acknowledgement of traditional ownership of this land reflects the confirmation of that ownership, unaffected by white settlement, as a result of the use and proof of history in one of the most important constitutional cases in Australia, Mabo. We're honoured to have Dr. Caitlin Goss present this third lecture in the Selden Society's lecture series this evening on the topic of using and proving history in constitutional cases. Dr. Goss is a lecturer at the T.C. Burnett School of Law. She teaches, she tells me not all at the same time, in subjects of the law of evidence, constitutional law and public international law. She obtained her Doctor of Philosophy in Comparative Constitutional Law at the University of Oxford, where she previously read for a Bachelor of Civil Law and a Master's of Philosophy in Law. Her postgraduate study was funded by a Rhodes Scholarship and also a commemorative fellowship from the Australian Federation of University Women, Queensland. Dr. Goss worked as the Associate to Chief Justice Holmes, then a Justice of the Queensland Court of Appeal. She tells me that was in 2008. It doesn't appear as though it could have been that long ago, but that's what she tells me. She has also previously worked as a solicitor and as a legal intern in the extraordinary chambers of the courts of Cambodia, which is a very lovely title for a court. Her research interests are in comparative constitutional law, constitutional theory, international law and the law of evidence. In this lecture tonight, Dr. Goss will explore the question of the role that history plays in the law and how claims about history are proved. She proposes to do this through a series of case studies with a particular focus on constitutional cases and exploring the challenges that come with using and proving historical facts and narratives in constitutional cases. Picking up where I started off, this topic had a particular resonance with me because of two things. The first is drawn from my former life, in which I was involved in appearing in many native title cases, in respect of which history plays a crucial role in proof of claims. And the proof of history in those cases at times posed very considerable challenges, although it is quite remarkable the sources and records that are available. The second aspect is a matter of really bread and butter for courts and tribunals, and that's statutory construction, in respect of which history of a different kind also plays a crucial role. But of course, tonight we're going to hear about the use and proof of history in constitutional cases, and would you all please join me in welcoming Dr. Goss.
Thank you, Justice Boskill, for your very kind introduction. Your Honours, colleagues, friends, former students, I know my current students are studying for their exam tomorrow. Thank you very much for coming here this evening. I feel greatly honoured to be asked to participate in the Selden series and greatly honoured to have you all here to listen to the talk. A prospective lawyer in the British American colonies in the years before the American Revolution had a limited choice about how to pursue their chosen trade. There were few colleges in the 13 colonies and no professorships in law were established until 1779. So for members of the founding generation, those lawyers who would go on in 1787 in Philadelphia in Independence Hall to draft the Constitution of the United States of America, what options did they have for pursuing their trade? Well, one option was to sail to England and to study at the Inns of Court. Charles Warren estimates some 115 American-born lawyers did this in the years between 1760 and the Revolution. As Martin Jordan Minot has written, 5 Middle Temple lawyers were signatories of the Declaration of Independence, and 7 contributed to the drafting of the Constitution. But it was expensive to go to the Inns of Court, and as has been acknowledged by one scholar, by the 18th century, the 4 inns had degenerated into little more than dining clubs with no educational value. So for those lacking the means or desire to go to England for their legal education, what did they do? Well, they pursued a program of clerkship with an admitted barrister and would then seek admission at their local bar. In theory, this clerkship process involved both practical tasks, which sound a little bit tedious, like copying contracts and transcribing documents in the era before ready reproduction. But it also involved wide reading from the library of one's lawyer master. This depended upon, what this looked like depended upon the lawyer. It was up to them to set the reading list. And some reading lists were rather more ambitious and aspirational, including everything from Pufendorf to Grotius to Hale and Fortescue. And others were a bit more realistic, a bit more limited and perhaps focused on the local statutes and court reporters. A student could gain access to their master's library. So one of the chief inducements for choosing a particular master was the size of their library. As McCurdy observes, for every Jeremy Gridley of Massachusetts, for example, who had some 700 books, there was a Nathan Tyler who could stuff his entire legal library into his saddlebags. Whatever the quality of education and whatever the method, however, there was a sameness. It involved a lot of reading, a lot of poring over texts, rereading and note-taking. In the founding father John Adams's words, "What books have I read? Many more, I fear, than have done me any good. I have read too fast, much faster than I understood or remembered as I ought." However one learnt the law, there was a technique that was almost universal, that of commonplacing. The law student would keep a kind of encyclopedia or glossary of principles and authorities across all subjects that they studied in a commonplace book. Commonplacing wasn't unique to the law, but it was a crucial part of any law student's study. The English philosopher John Locke recommended commonplacing as necessary for all gentlemen, especially students of divinity, physics and law, and advised students to take a blank book, create an index and assign each section to a letter in that index. McCurdy observes that although this process of commonplacing aided students' comprehension, it did add to the tediousness of study, and the results for recent undergraduates now taking on a practical training in the law could be depressing. Dismay became the order of the day for many students, he says, especially those fresh from college and the lyric poetry of Ovid and the precise couplets of Pope. Apart from helping to establish that no matter the circumstances, law students will complain that they have too much reading, why ask the question of how lawyers in this era studied and who they read? Well, since the 1980s, originalist theories have been on the ascendancy in the Supreme Court of the United States. Early incarnations of originalism really focused on understanding what the founders meant, understanding their intent, and thereby interpreting what they would have wanted a constitutional outcome to be. In later and now more popular incarnations of originalism, we see more of a focus on original public meaning, or what words would mean to an ordinary speaker and perhaps a lawyer working in that domain. Depending on your originalist persuasion as a member of the Supreme Court of the US, it may or may not matter what the founders thought on a particular topic. But knowing what founders read, knowing what the drafters thought legal concepts and words and ordinary words to mean, can help you in understanding the original public meaning, at the very least, of the Constitution. And this is something that the Supreme Court of the US has taken a particular interest in. When they're turning to understanding what the founders thought of the law. In the Virginia Law Review, in a recent article, Martin Jordan Minot provided an extended discussion of the Supreme Court's habit of referencing William Blackstone's commentaries. As Minot observes, since 1990, the Supreme Court has referenced Blackstone in 8% of all of its signed opinions, the highest rate since 1810. Minot discusses this pattern. Justice Scalia likewise cited Blackstone's conception of corporations under the common law in his concurrence in Citizens United. In the last century, Justice Blackmun relied on Blackstone's contention that abortion had been permitted before quickening in Roe v. Wade. As a matter of legal precedent, the court has decreed that Blackstone constituted the preeminent authority on English law for the founding generation. At least in the eyes of the court, Blackstone is a quasi-mythical being, the oracle of the common law in the mind of the American framers. As Minot says, such exalted status of a single 18th century legal work and its author is remarkable. At least one commentator pointed out that the court sometimes proceeds as if the US founders understood the Constitution to silently enact Blackstone's commentaries in between or underneath the constitutional text. Now, the only problem with this emphasis on Blackstone as the most influential author for the founding generation is that although he is the most influential surviving author's work, his work's the most influential surviving material from that period in our understanding of the common law, he was not, for the founding generation, it is argued, the most influential author. As McCurdy and Minot and others have argued, Blackstone's writings didn't gain prominence in the United States, although he was writing at the time of the founding generation's education, until after the American Republic had been created. If we accept this argument, the Supreme Court's confident and frequent reliance on Blackstone in order to establish the state or understanding of the common law at the time of the drafting of the US Constitution appears therefore to be overstated at the very least and perhaps mistaken. Not only did Blackstone not represent the dominant understanding of the lawyers who were part of drafting the Constitution, but his influential work changed the way they and others would later understand the common law. So it could not have represented what founders learnt about the law in the period prior to the Revolution. How do we know all of this? Well, we go to the reading lists and we go to the commonplace books. Minot writes that the first American edition of Blackstone's commentaries appeared only in America in 1771. It was distributed by a publisher in Philadelphia, and subscribers it did include figures like John Adams. But even by 1776, when it came time for Adams to recommend books for his own students to follow, he did not even mention Blackstone. At the time, Edward Cook's Cook on Littleton was the most commonly prescribed text on reading lists, and it was the book a lawyer would have if they had no other. McCurdy argues that Cook stood without rival in the English-speaking world in the last years prior to the Revolution. In addition to these lists, Minot has completed original research going through some of the surviving commonplace books of figures who went through their legal education and training in the period leading up to the Revolution. He has analysed these texts, including the commonplace book of John Marshall, who would go on to become the fourth Chief Justice of the United States. And the books of this era show that students relied on Cook or Cook via Bacon and any number of other texts, including law reporters, but none relied in any significant way on Blackstone. Blackstone's commentaries would go on to transform our understanding of the common law and to dominate the understanding of the common law in the early years of the Republic, but it had not yet done so. One of the reasons the commentaries attained such significance in the early Republic was that they represented a big change in the way of thinking about the common law. Blackstone simplified, categorised the common law. He gave it unifying principles, replacing the sort of chaos and piecemeal nature of some earlier works. McCurdy describes how difficult many students had found their law studies in the era prior to Blackstone, noting that Coke had reduced future Supreme Court Justice Joseph Story to tears. And indeed, other members of the founding generation wished that they could have learned the law in the influence or era of Blackstone. John Adams remembered his legal education as having been a dreary ramble before Blackstone's commentaries had arrived to smooth the path of the student. Not everyone agreed with this. Thomas Jefferson, for example, believed that the commentaries were anti-republican, conservative in nature, and that as they retained their ascendancy, from that moment the profession began its slide into Toryism. So there were mixed views, even amongst the founders, as we expect from the founders on so many things. But what does all of this tell us about legal interpretation and about history? Firstly, it highlights how easy it is to make and accept claims about history that might seem quite general and uncontroversial, and for those claims, in fact, to be in error or anachronistic. It also shows us how difficult it can be to obtain accurate historical information about something as simple as what was the text that dominated the studies and understanding of a particular era. We've seen that Minogue's work required trawling through the surviving notebooks of law students and set texts of reading lists. It also shows us that given how influential Blackstone's commentaries have been in a number of controversial cases, some of which are cited on the slide there, that history can play an important and determinative role in constitutional cases. And if it plays such an important role, then getting history right, or at least not getting it wrong, becomes important in itself. So where to from here? Should we conduct our constitutional inquiries in an ahistorical vacuum? Should we simply try to do history better? Why do lawyers and judges turn to history in the first place? In this talk, I want to begin to think through some of these questions about the ways in which history is used and proved in constitutional adjudication, and to think through the possibilities and challenges of doing so. Typically, when we think of history in the context of constitutional adjudication, we tend to think about cases like the one I've just described, where we're thinking about original and historical meaning. But I think that if we take a broader view, we can see that history comes up in all sorts of ways in constitutional cases. And that's what I want to expand upon today. In the first part, I will be looking at the way in which history and historical narratives come into constitutional texts themselves. Then I will look at the different ways in which, even without explicit incorporation, history comes into constitutional adjudication. And finally, I want to reflect on some of the challenges in using and proving history in constitutional cases, picking up on some of these themes already under consideration in relation to Blackstone. In broadening this focus, I also want to broaden a focus away from just thinking about originalism. I don't propose to engage with a substantive debate about the merits and theoretical ideas underlying originalism. That is a rich debate and one well beyond the scope of this lecture. But the arguments I make do raise some methodological challenges or epistemological challenges for originalism about how we are to use history and prove history if it is relevant to our considerations. And in this paper, I don't want to argue against using history, but to show that history, like other extra textual sources of interpretive material, can be subject to argumentation, that it is not a strictly neutral area that is easily provable and knowable, even though as lawyers we might sometimes feel that history is easily within our grasp. So first of all, constitutional texts and history. What role do historical facts, claims and values play in constitutional texts? A survey of world constitutions conducted through the Constitute Project database reveals that references to history and historical facts are common in many world constitutions. They come up in lots of different ways, in preambles and in the bodies of constitutions, and are used for different purposes. I want to briefly identify a few different attitudes towards history that can be identified in relation to constitutional texts. First of all, some constitutions reference history in order to reject history or to reject the past, to found the legitimacy of the new constitutional era on the illegitimacy of the previous era. The Hungarian scholar András Sajó and judge András Sajó has argued that constitutions, rather than being forward-looking, reflect the fears originating in and related to the previous political regime. Many of the post-communist constitutions in Eastern and Central Europe were examples of this, rejecting their previous era. In Iraq in 2005, the constitution clearly rejects the sectarian oppression inflicted by the autocratic clique, recollecting the darkness of the ravages of the holy cities. Other constitutions take a different attitude or approach and found their legitimacy on a connection with the past rulers, past glories of the kingdom, and so forth. The current Egyptian constitution refers to the great ancestors in the ancient era and reflects upon the building of the first state on the banks of the Nile. Beyond these grand and preambular references to history in constitutions, we also see instances where history is used specifically to justify particular provisions. So it is used, for example, in the Rwandan constitution, the post-genocide constitution, to justify a number of particular provisions, including the presidential term. A final and interesting category of reference to history in constitutions is that a number of constitutions mandate the teaching of history, of national history. And in the case of El Salvador, mandate that this teaching is done by someone of Salvadoran nationality. Of course, these examples I've been discussing are explicit references to history, and you'll all appreciate that many constitutions are deeply informed by history and must be understood in light of history without ever appearing to make a reference to it. In order to understand the meaning of dignity in Article 1 of the German Basic Law and how that is an inviolable principle, it is necessary to have an appreciation of that country's history. Similarly, the reference to the Carpathian Basin with its outwards reaching geographical claims in the Hungarian Constitution of 2011 is and must be informed by an understanding of recent nationalism in that state. A constitution that refers extensively to history and in which history has been used in constitutional adjudication extensively is that of the Republic of South Africa. In South Africa in the late 1980s and early 90s, we will recall that after decades of anti-apartheid activism, there were finally genuine discussions about fundamental change to the South African state. Following Mandela's release after 27 years in prison, representatives of the African National Congress and the National Party in power, as well as other groups, began negotiations about constitutional change. Now, at first there was a great deal of mutual suspicion between the parties. Periodic violence was breaking out, and these were parties that had effectively been at war for several decades. There began to be an agreement that change was necessary and that the constitution would need to be replaced wholesale. But there was a lack of agreement about what that change should look like and how it should be accomplished. The ruling National Party wanted the constitution to be enacted, the new constitution to be enacted under its authority and under its control to a large degree. The ANC wanted a constitution to be adopted by a new, properly democratically elected body. And the parties reached a deadlock, each unwilling to give up on the promise either of stability or great change. The solution they reached was to adopt a two-stage interim constitution and permanent constitution. So the interim constitution would be drafted by the negotiating parties who were not democratically elected but who represented various groups, and that would operate until it was replaced by a permanent constitution, which would be drafted by a fully democratically elected constitutional assembly. That was almost enough to get the parties to agree, but there was a question still of how you could guarantee that it would meet the expectations, at least in large part, of parties in the negotiating process. And so they came up with the innovative solution of 34 constitutional principles, which were included in a schedule to the interim text and against which the permanent constitution would have to be measured. They created a constitutional court which had the task, for the first time in the world, of certifying the permanent constitutional text against those principles. And indeed, the first time a draft was submitted to the court, it declined to certify on the basis that it had failed to meet some provisions, including those relating to federalism. Eventually, the Constitution was certified and enacted, and the question now turns to how this has affected South Africa's constitutional jurisprudence. The post-amble to the interim constitution states that the temporary text provides an historic bridge between the past of a deeply divided society characterised by strife, conflict, untold suffering and injustice, and a future founded on the recognition of human rights, democracy and peaceful coexistence and development opportunities for all, irrespective of colour, race, class, belief or sex. And the court has held that the Constitution represents a radical and decisive break from that part of the past which is unacceptable. In interpreting this deeply historically informed constitutional text, the Constitutional Court has developed a rich jurisprudence that has been affected by and in the context of history. And they did this right from the start, even while they were under the authority only of the interim constitution and the permanent constitution was still being drafted. One controversial issue that the parties had not been able to agree upon in their negotiations was the death penalty. But this came before the court during the interim era, and they determined that in light of the rights contained in the Constitution, interpreted in the context of the historical context of South Africa, that the death penalty was in fact unconstitutional. And this interim era constitutional decision has been reenacted and reinscribed in the values of the Constitution in the permanent constitutional era. But even in more recent and much more mundane matters, such as the decision of Rustenburg Platinum Mine and the South African Equity Workers Association, we see that constitutionally enshrined historical values play a determinative role in the adjudication of disputes. In Rustenburg Mine, the Constitutional Court considered an unfair dismissal claim by an employee, Mr. Bester. He had referred to a fellow colleague as a swart man or black man in the context of a dispute over a parking space. And the question arose as to whether his use of this language in that context was derogatory and racist, such as to justify his dismissal. Bester's unfair dismissal claim went before a conciliation commission, whereupon the commissioner found that the dismissal had been unfair on the grounds that I do not really see how such a phrase, referring to a physical attribute in order to identify a certain person, could be classified as a racial remark. It would be similar to a situation where someone comes into our offices not knowing my name and then asking for me by stating the wit man who parked next to the entrance gate. I will not take any offence to this. The decision went through several rounds of appeals before it was finally heard by the Constitutional Court. All parties agreed that the relevant test was whether Bester's statement constituted derogatory language and whether that test was an objective one. In other words, in the opinion of a reasonable person possessed of all the facts, Mr. Bester's use of the words swart man in this context was derogatory and racist. The court acknowledged that this was the first time it had had to consider this kind of matter, whether, as it said, an apparently neutral race descriptor may be regarded as racially abusive or insulting. But in reconsidering the decisions below and overturning the decision that it was an unfair dismissal, the court held that the decision below that the words were presumptively neutral fails to recognise the impact of the legacy of the apartheid and racial segregation that has left us with a racially charged present. This approach holds that the dominant racist view of the past, of what is neutral, normal and acceptable, might be used as a starting point in objective inquiry without recognising that this root of the view skewers such inquiry. It cannot be correct to ignore the reality of our past, of institutionally entrenched racism, and begin an inquiry into whether or not a statement is racist and derogatory from a presumption that the context is neutral. The past may have institutionalised racism, but our Constitution constitutes a radical and decisive break from the past. This case shows us how important historical values enacted into a constitution can be. The historical context here made what might otherwise have been an ordinary labour dispute with no constitutional significance into a matter for which the Constitutional Court granted leave to appeal, and then upheld the appeal. In this case, the historical context also determined the outcome of the case. And it's one of many examples, including the earlier death penalty decision of Makwanyane, where the court has used historical context to uphold and change the country's constitutional values. Moving now to situations not relating to constitutional texts embodying historical facts or events, but constitutional adjudication. I want to think through some of the other ways in which history can come to play a part in constitutional cases, before delving into a further case study on Canada. Firstly, matters of history often arise in constitutional cases and many other cases in determining something to do with the history of the common law. We see this in, for example, whether something was a constitutional right, whether something that preceded the Constitution has been altered by the Constitution, and so forth. For example, in Australia, the High Court has held that the privilege against self-incrimination is not a constitutional right, but is a deeply ingrained common law right. And in doing so, judges have reflected upon the history of the privilege, noting that it is generally recognised that it emerged as a reaction against procedures of the Courts of Star Chamber and High Commission, and in particular, the inquisitorial oath, where someone could be compelled to speak against their own interests, and then that could be used against them. Secondly, there are constitutional cases where historical facts may constitute a fact in issue. In the United States, in the case of the United States and Michigan, for example, a US District Court case, the status of treaties made with Michigan tribes Michigan Indian tribes in the 1830s under Article 6 of the US Constitution depended in part on historical evidence as to the history of land use in the session from 1836 to the present, as well as an analysis of the intentions of the Treaty Commissioner based on historical evidence. As Justice Boskill has alluded to, this is something we're familiar with in native title litigation in Australia, and cases such as Yorta Yorta have involved extensive matters of proof relating to history in litigation. In such cases, it will not be possible or desirable, of course, to avoid historical questions, but we still may have challenges about how to prove that history. Thirdly, some cases of constitutional significance have required courts to assess the constitutionality of what we might call legally protected history. Briefly, by way of example, the French Conseil Constitutionnel and the European Court of Human Rights have recently had to consider challenges to laws prohibiting the denial of historical events, including in relation to the Armenian genocide. So, finally, to return to where we began the lecture, historical arguments may be used in many cases to interpret a constitution. I want to go to another example of using history to interpret a constitutional text, but in a very different constitutional environment to that of the United States. I'm going to address the case of the Crown and Comeau, which is a Canadian case. And as many of you will be aware, Canada, far from hewing to an originalist framework, adopts a living tree approach to understanding its constitution. The Comeau litigation holds some similarities to Australian cases that relate to Section 92 of our Constitution, such as Cole and Whitfield. In the province of New Brunswick, Canada, the government is in the business of vending liquor, and it imposes, via the Liquor Control Act, restrictions and penalties on those who would purchase more than a given quantity from non-government corporation-owned businesses. On the 6th of October 2012, Mr. Comeau, the defendant in this case, was an enterprising resident of New Brunswick who drove across the border to the more liberally minded Quebec to purchase alcohol, more specifically 15 cases of beer and 3 bottles of spirits at 3 different stores, to avoid the higher prices caused by the New Brunswick litigation. Unbeknownst to Mr. Comeau, he was under surveillance by the Mounties and was promptly fined for holding a relevant quantity of liquor purchased from a non-corporation vendor. He contested the fine on the basis that the Liquor Control Act was in violation of Section 121 of the Canadian Constitution. That section states that all articles of the growth, produce or manufacture of any one of the provinces shall, from and after the Union, be admitted free into each of the other provinces. So at trial then, the key question was, what does admitted free mean? Is it effectively a guarantee of free trade, or is it some more limited prohibition on customs and tariffs as between provinces? Ultimately, the trial judge found in favour of Mr Comeau and his noble quest for cheap beer and said that the Liquor Control Act was unconstitutional. The question for our purposes is not the correctness of that decision or even the correctness of the historical conclusions reached, but rather the way in which they were reached and the evidence that was used. The background to the findings about the historical meaning of the Constitution must be considered in light of the Gold Seal decision, a ruling 1921 Canadian Supreme Court decision. And this was the decision which the trial judge in Comeau departed from. Gold Seal established that Section 121 was more of a prohibition on customs duties or charges rather than a total guarantee of free trade. And so the evidence relied upon at trial had to overcome this assumption. In the decision at first instance, His Honour begins his judgment by establishing the usual canons of Canadian jurisprudence. The Constitution requires a flexible interpretation in line with the living tree metaphor, which has been applied by the Supreme Court in many cases. However, the meaning of the words must still be placed in their proper linguistic, political and historical contexts. In the Canadian approach, the views of the founders do matter, but they matter less over time. So what was the evidence in this case? Effectively, the findings in this case were made on the evidence of a single expert, a historian, Dr. Smith. His report drew on a number of different sources, including primary materials, speeches of relevant historical figures, and different constitutional drafts and legislative texts. We see in the second quote on this page that the trial judge referred to Dr. Smith's credentials as unimpeachable, his testimony as beyond reproach, and noting that he accepts the historian's testimony without hesitation. On the basis of Dr. Smith's evidence, the trial judge concluded that the Supreme Court's decision in Gold Seal was decidedly not what was intended by the Fathers of Confederation. Looking at the judgment, several things are apparent. First, at times the views of the founders, and even broader groups of people, are described as though they are monolithic, uniform, and clearly knowable. It is said the positive benefits of free trade and the negative effects of trade impediments were well known to the Fathers of Confederation and to the politicians in Great Britain during the events leading up to Confederation. Both shared the philosophy that the creation of a true common market would be beneficial. Secondly, one challenge that arises in this case, as in other cases involving historical conclusions, is that it is difficult to know what the basis for any given conclusion is. Some appears to be based on judicial notice, some on the evidence of Dr. Smith, but it becomes very difficult to analyse the correctness or even basis for a number of the claims without having clearer information on what source justifies a conclusion. Thirdly, the precise scope of the expert's expertise is not defined and seems to be wide-ranging, extending across a number of matters including history, linguistics, economics and law. These matters include the reasons for the economic success of the British colonies, an analysis of the opinions of most Americans, and the assertion that people associated Britain with fair trade. The lack of clarity about his expertise and the scope of the expert evidence given appears to be in contrast with the court's normally cautious approach on expert evidence, where, for example, a generalist doctor would probably be unlikely to give evidence on a specialised matter of medical practice. Fourthly, it is striking that the historical expert provides opinion evidence on the correct legal interpretation of the Constitution, including the significance of the placement of Section 121 in Part 8 of the Constitution and the way that the words admitted free should be interpreted in light of earlier constitutional drafts. As the Supreme Court later observed, it is difficult, if not impossible, to contemplate a situation where evidence on the drafting and meaning of domestic law would ever be admissible as expert evidence, as it is not something outside the knowledge and experience of a judge. Jason Chin has observed that the use of this evidence seems to contradict the principle that expert evidence should only be admitted if it is necessary to the finder of fact, and it also appears to be in tension with a caution around ever admitting expert evidence on questions of legal interpretation, especially from a witness who is not, in fact, legally trained. On appeal to the Supreme Court, a unanimous bench overturned the trial judge's decision on several grounds. First, the court found that even if the expert's testimony had established a new interpretation of historical facts, that was not enough to overturn vertical stare decisis. The court concluded that the mere existence of that evidence does not permit the judge to depart from binding precedent. The Crown's success on this grounds of appeal was sufficient to overturn the matter, but they did also go on to consider in part the historical claims that were made. And the Supreme Court provided its own analysis of history about the state of export trades, customs and duties at the time and so forth. And they concluded that the phrase admitted free, they conceded that it was ambiguous, but they said there was limited evidence at best to conclude that it was a provision in favour of total free trade. Why focus on a decision of a provincial court judge that has since been overturned by the Supreme Court? The point is not to criticise the conclusion reached by the judge or even the historical approach, because a number of scholars have argued that the trial judge's approach and the acceptance of the expert's history does accurately reflect the constitutional history of Canada. And a number of scholars and authors have also contested the Supreme Court's approach to stare decisis and precedent as being more restrictive than its past practice. But whilst the legal discussion on these matters is now effectively closed unless the Supreme Court decides to reconsider the matter, the historical argument is not closed and is very much open for debate. What this case demonstrates to us then is that history can be influential and determinative in constitutional disputes, even where you're in a jurisdiction that is not originalist in its interpretive methods, and that getting history right can be difficult and also a matter of ongoing dispute. In the final part of this talk, I want then to briefly consider some of the challenges that I've already begun to allude to around using and proving history. Approaches to history and constitutional interpretation, of course, vary from place to place, and members of this audience will be well aware of the path the High Court of Australia has taken in relation to constitutional interpretation and using history, in slowly increasing the amount of the willingness to use history in cases like the Communist Party case and Cole and Whitfield. But the observations I make here are not confined to one jurisdiction. As Professor Helen Irving has observed, these issues are common across many constitutional cultures. So very quickly, some thoughts. First, across many jurisdictions, there is a lack of clarity as to why and when history will be used. History is cited in some constitutional cases and not others, and it is not always clear what the rationale for this is. It is difficult to avoid at times a feeling that there might be some cherry picking of historical data going on, using history when it helps to support a conclusion and not otherwise. This brings to mind the memorable words of Judge Harold Leventhal in the context of using legislative history, that it can be akin to looking over a crowd and picking out your friends. Secondly, sources and standards of proof for accepting arguments based on history. This is an area of ambiguity and, in some cases, some challenges. We've seen from Comeau, at both first instance and on appeal, how determinative history can be. And yet we have a lack of clarity around how it will be proved. Some of this relates to the distinction between adjudicative and legislative or constitutional facts. There can be an ambiguity, as Dyson Hayden has argued, as to when something might be a legislative or a constitutional fact versus an adjudicative fact that needs to be resolved as a fact in issue in the case, and the different standards and approaches to proof that come with these distinctions. Hayden singles out the case of Brown v. Board of Education from the US Supreme Court as a case where there is an ambiguity about whether those facts should be viewed as adjudicative or legislative. Moreover, where they are constitutional or legislative facts, there can be a lack of depth or precision in proof and a lack of clarity as to what sources were relied upon to prove constitutional claims. As to sources, each source of proof has its own challenges. We've seen the challenges associated with expert evidence in the Comeau case, but other methods of proof come with their own complications. If parties to a case have agreed facts or agree on certain historical context, that might not be problematic at the case at hand, but if it is picked up and adopted in subsequent cases where the parties to the given dispute are no longer present, it can influence our ongoing understanding of history, if it is accepted uncritically by the courts. Moreover, judicial notice, especially where the party is not given the opportunity to comment on sources being consulted or conclusions being reached, can result in unfairness for the parties. And this can all make it hard to assess historical claims and conclusions that have been reached. Thirdly, and more fundamentally, there is the challenge of getting historical questions and claims right, and whether this is indeed possible. As Bradley Selway QC observed not long before his elevation to the federal court, one of the conceits of the legal profession is that its members are necessarily good historians. Selway observes, experience shows that this is not true even of all historians. There is no obvious reason why it should be true of lawyers. And indeed, many scholars writing in this area have observed that lawyers feel a particular affinity and comfort with history. We're used to sort of fossicking in the history of the common law and understanding laws and cases through a historical prism. And so we might feel more able to approach that than other matters of expertise. And many of these scholars also note that have criticised the tendency of lawyers to generate what they call law office history, or sort of convenient, good enough histories that will serve a purpose in a given case. And of course, lawyers and judges are subject to much more immediate and practical demands of resolving disputes rather than reflecting at length on history. Helen Irving has said that if judges are to use historical accounts to reach their legal conclusions, they should do so carefully and circumspectly. They should say why they have chosen particular historians over others and on what basis. But even scrupulous judges, she argues, should not allow historians to settle the law. That is, should not allow the outsourcing of their decisions wholesale to secondary texts. Ultimately, Irving elaborates so many concerns about the use of history that she concludes that wise constitutional interpreters, in other words, avoid using history. Now, her focus here is on history and constitutional interpretation, not cases where it might, for example, be a fact in issue and therefore unavoidable. And this connects us to a deeper point, again something that Justice Boskill has referred to, which is the question of the indeterminacy of history and who writes history and whose accounts of history are referred to. There are deep debates in history about whether history is radically indeterminate, whether it should be talked about at all as a set of sort of facts and conclusions that can be drawn, or whether it's something that is constantly open to negotiation, disputation, re-engagement in light of new sources and so forth. That is well beyond the scope of this lecture, but what I do want to identify is that there is a potential for indeterminacy in history, and that as lawyers we often don't account for that potential. We see history as often as a neutral or accessible source that can be resolved, and we need to recognise, as Renata Utes has argued, that there is a great possibility for constitutional indeterminacy and historical indeterminacy. Moreover, when we think about history, we think about the accounts that have dominated and prospered from the periods in which they are written. We think about Quick and Garran. We don't think about other accounts that might also have perspectives on how the law operated at the time. Fourthly, one reason to have a particular concern and caution around the use of historical evidence is that the adoption of a historical account in a judgment of a superior court can have an effect beyond the case at hand. The American scholar Alison Orr Larson discusses this, the idea of what she calls factual precedence, or the tendency of lower courts to rely upon Supreme Court factual findings and to reapply them without reconsideration. She says this is evident when courts invoke what the US Supreme Court has said about history without re-examining the historical data. For example, the Supreme Court's explanation in Hands in Louisiana on the origin of the 11th Amendment has sparked tremendous debate among historians and jurists as to its accuracy. Some historians suggest that the court strategically selected statements from the framers to justify its historical account, ignoring original evidence to support the opposite constitutional understanding. Right or wrong, she says, the Supreme Court's history on the 11th Amendment is the only historical account on the subject that matters now, because it's the one that binds lower courts for questions of state sovereign immunity. The possibility of this factual precedent, or the tendency of a particular kind of legal finding on history to have a knock-on effect, is particularly great in an area like constitutional law, where these matters are rarely considered and decisions often are long-lasting and difficult to shift. So a statement on history in one case might have long-ranging effects. If we do not wish to give up on history entirely then, where should we start? One place to start would be a call for humility and caution in relation to historical arguments and claims in constitutional cases. Constitutional interpreters relying on historical evidence might draw upon some of the lessons that comparative constitutional lawyers have learned. From Monod's work on Blackstone, we saw how difficult it is to see the past without seeing it through the views of the present, how easy it is to make the mistake that the most famous surviving works of the late 18th century were the most dominant and influential works of that same period. How can we learn from comparative constitutional law? The claim may at first seem counterintuitive. Historical evidence has the advantage of being part of the same legal system or part of the same legal tradition, and will normally be in the same language and within a context that the lawyer is more familiar with. But on a closer examination, a number of similarities arise. Knowledge of language, context, cultural practices, and how to assess particular sources from a given era or place may be required in historical findings just as they are in comparative jurisprudence. Those engaging with legal history may be just as guilty or prone to cherry picking as those engaging in comparative jurisprudence. So thinking about when and how historical evidence should be used could be important. Evidence about an earlier time in a legal system may be coloured by our own contemporary perspectives, just as our analysis of another nation's legal system is inevitably coloured by our understandings and training in our own legal system. We might find, following L.P. Hartley's oft-cited words, that the past is a foreign country. They do things differently there. In his book, Comparative Matters, Rand Herschel, in discussing the tendency of comparative constitutional lawyers to view other case studies through their own experiences, he cites the comment of Marco Polo in Invisible Cities. "Every time I describe a city, I am saying something about Venice." Tonight, I have taken us to a few other constitutional cities, and perhaps, I hope, given us some things to think about in our own city. Thank you.
Thank you so much, Dr. Goss. I'm sure you'll all agree that we have been treated to a fascinating and broad-ranging exploration of the topic. I think you have indeed given us something to think about in our own city, if we might transpose that to our own country. I had in mind the contemporary issue about the recognition of First Nations people in the Constitution and a constitutionally enshrined voice to Parliament for Indigenous people when you were talking about references in constitutions elsewhere. So that's very much a contemporary topic. We greatly appreciate the time and effort. It can't be underestimated how much work goes into such a detailed and learned presentation as we have benefited from tonight. I heard a fabulous phrase listening to an interview on Radio National going home last night, which was that the sieve of history has very large holes. And I had that in mind as I was listening to Dr. Goss from a few perspectives, one of which is it reminds us of the importance of humility and caution in considering the matter of history, because there might be things that are missing that have fallen through the large holes in the sieve, but of course many good things are captured. But the other thing is that it underscores the importance of a society such as the Selden Society and lectures such as this, which support and reinforce the importance of learning, capturing information and utilising it in the work that we all do, whether it's in academia, the courts or elsewhere. So very far from reducing us to tears that might be suffered by the law students of today and the past, we have been informed and educated and enlightened, and we thank you very much. And would you all join me in thanking Dr. Goss again. There are now refreshments that will be served outside. Thank you.